Okay, that's the testimony of a jailhouse informant that's saying Segura had admitted to killing all four of these folks. Gene Rossi at the DOJ for 30 years, over 100 jury trials, prolific records, trained over 1,000 baby prosecutors, and the thing that always gets me jealous is there's actually a Gene Rossi war room at the DOJ. Gene, welcome.
I love when you say that. Good afternoon.
Gene, so, all right, work with me on this, all right?
I do.
Let's get our abacus out first. John Carlos Santos, serving a federal prison sentence, who refused to testify at the first trial where there was a hung jury because he asserted his right to remain silent, testified in this case that he's the one who ordered the hit because James Santos, being told, I'm sorry, I apologize, he ordered the hit because of $100,000 or $90,000 that was stolen by Brandy, and that this was to make a point. We have the spade, we have female DNA underneath the fingernails, as well as male DNA. It doesn't match the defendants by a phone cord, so multiple people were inside that home. Nevertheless, he says that Angel Quinones did this. The defense put him on the stand to say, I didn't do this. I don't know these people. Talk to me, brother. What's happening?
This is the most convoluted criminal case I've ever seen, where the defense is putting on probably a stronger case than the prosecution. I do want to comment on this last witness, the jailhouse snitch, if you will.
But we're going to get to him, Gene, in a second.
Okay, good.
I'm just curious, like, was there a tactical reason? Like, and there could be, I don't want to second guess them. Maybe they just want the jury to see the guy. But you already had Santos's testimony that he's the one who ordered the hit and who did it. The defense isn't obligated to call that person. And certainly, I mean, it'd be great if the guy said, yeah, I did it, but he's saying I didn't do it. What are you making of it? Can you think of a tactical reason to call it as a defense attorney? You already had the information that was valuable and could cast reasonable doubt to the jury.
Yeah, okay, just so I'm clear, he took the stand, Santos, and said, I did not do it?
Yeah, I don't know these people.
Okay, after he told people he did do it.
Yeah, so Angel's.
Yeah.
So my producer want to make sure we get it right. Santos testifies that he's the one who ordered the hit and that
Correct.
Angel Quinones did it. So that's great testimony. Why put Angel on the stand to say I didn't do it?
But the government called Angel.
Oh, you know what? I apologize. I'm being told he's a rebuttal witness. I thought he was being called by the defense in the case.
No, that's where you're confused.
Yeah.
No, that's why my head is spinning. The government called Angel. Let me comment on the government's calling Angel. I see why they called Angel.
Yeah.
Testimony is Angel's not in a courtroom. Angel's in some room in Italy. And I don't know if he's incarcerated or he just walked off the street after working at a construction site. But I doubt Angel's going to say 1,000 miles away, hey, I did it. Okay? Yeah. So he's going to say, I never heard of these people.
Well, it makes perfect sense now to me, Gene, because I'm sitting here thinking that the defense called him. So I apologize for that. But it makes sense for him to say, it's basically attacking Santos's credibility by saying, yes, I had nothing to do with it. Okay, let's go to the other part where you want to go, where the cellmate is testifying, and talk to our audience about the dangers in the rebuttal case for the prosecutors in calling that cellmate.
Okay, the biggest issue for what a jailhouse snitch, as they call it, a cellmate, is what is the benefit that the witness is going to get from the government by allegedly testifying to an alleged confession of the defendant. That is a very risky move. And I've seen jailhouse snitches testify, but oftentimes there's a recording. They're wearing a wire that the government gave this guy when the defendant was in jail confessing. When it's just the witness's word against the defendant, you know, you have to get into where was this conversation? How much information, and this is key, how much information did this witness have before they allegedly heard this confession from the defendant? Was the witness repeating something in People magazine or on the front page of a newspaper? or did the defendant really provide this? I have called a snitch just like this guy, and the jury believed him, but it's a risky maneuver.
Yeah, and that's why we don't like getting a lot of data out in the media, for the very reason that you brought up, that they could be fed that information and trying to get themselves a break. So cross-examination of the cellmate must surely be interesting, certainly something that's going to be aggressively pursued for the reasons Gene spoke about. Let's take a look at that. Yeah, you gotta love that. Not only is that not accurate, but you gotta love the guy. The defense lawyer went right where you gotta go, cross-examining this jailhouse informant, if you will, that new charges, new offenses would have been brought against him if he didn't come forward. And then, Gene, this is where you strike the gold on cross-examination. Your witness, your great character witness, is talking about the differences between the federal and state legal systems in terms of the manner in which prosecutions occur, which obviously communicates to the jury this guy's been around the block. I mean, all right, go ahead. What do you think?
I got to tell you, in my closing argument, when I talk about Mr. Kelsey Kennard, I would just have a field day. First off, he is absolutely wrong about the federal system. It's called the Rule 35 motion, and it is absolutely crystal clear to me that this guy could be possibly facing federal charges or serving a federal charge, and he's hoping to get a reduction in a federal charge and even a state charge. He is crazy that you don't have to tell anybody that you may get a cut in your sentence. That's the whole purpose of the famous case called Giglio, a benefit to a witness that's called by the government.
Yeah, and the beauty of it is, production of information in a trial is from the lawyers in the legal system and the prosecutor. And so this guy's trying to explain why he didn't produce something. Oh, God, I got to take a break. We'll be right back.